Jagersfontein tailings mine disaster. The Mineral Resources Minister, Gwede Mantashe, has said that he believes one of the reasons the tailings dam collapsed in the Free State is because his department is not actually allowed to inspect the dams. He says under a court ruling from 2009, the material in a tailings dam is considered movable property and private property, and thus government cannot actually interfere with them. Professor Tracy-Lynn is a professor of environmental and sustainability law at Wits University. Professor Field, good afternoon to you, and thank you for your time. There's been a lot of talk in the last few days about this judgment from 13 years ago. Do you agree with the minister? Does this department simply have no jurisdiction over a tailings dam?
So I agree with the minister that it's a problematic judgment. I disagree with the minister that they couldn't have done something about it.
Why do you say that?
So this judgment was essentially around whether the department could grant mining rights to mine the material that's left in these dumps. And then in this particular case, there was still a lot of valuable material. I've heard that the mine was producing something like 28,000 carats a year. And so they wanted to be able to license it under the Mineral and Petroleum Resources Development Act, which is our mining law, and which was passed to transform and to give ownership of the minerals, to South Africans really. But a lot of these dumps, waste rock dumps, tailings facilities were created before the Act came into effect on the 1st of May 2004. So they're historic tailings dumps. And so De Beers was in control of the facility at that time, and then the DMRE granted a mining right to another entity, which was Atakwa Mining. And then De Beers tested this in court, whether the department had jurisdiction over these historic tailings facilities, and the court agreed with De Beers and said that because of the way that the law had been drafted, the way it defined minerals, the way it defined mining, that they weren't actually mining, they were processing, and this was a movable facility. So it did mean then that the department had no authority to grant mining or prospecting rights over these facilities. So in that sense, the minister is correct.
It's one thing to say that no one else can mine something that actually belongs to something else or was produced by someone else when they were mining for diamonds. I understand that. Does that absolve the Mineral Resources Ministry from any legal duty, or what's the legal phrase, obligation, I suppose, they may have to actually make sure that a mine and the mine owners are still managing their property in a way that does not affect other people?
I agree with you that it does not absolve them from responsibility, and the minister has a constitutional mandate to regulate mining in this country. And they have tried. They've tried amending the law in 2013 to change the definition of residue deposit. And that hasn't been tested in court, but the big five firms in Sandton will tell you that it still hasn't brought these mining dumps into the net. And then they made another attempt with an amendment bill in 2013 that included many other important amendments. And they haven't been able, his department has not been able to push that legislation through in Parliament. And this problem could be resolved. They have the constitutional mandate to do that, to change the law, but they haven't done it.
You say that they have a constitutional mandate to do it. As I understand the law, and I'm not a lawyer, as I'm reminded constantly, that you can't go backwards. You can't have retrospective. In other words, you can't prosecute someone for going faster than... You can't change the speed limit and then prosecute someone for breaking the new speed limit when they did it a week ago. Doesn't the same apply here? In other words, if there was a mine owned by a mining company and they built a tailings dam and they left the tailings dam, you can't 20 years later come back and say, no, you have to do this and that.
Okay, so if you study law, Stephen, you'll learn about principles of statutory interpretation. And there is an assumption that the law was not retrospective. It doesn't apply to things that applied before it came into effect. And that's a basic principle of fairness. But the legislature can expressly say that it applies retrospectively. And you've got an example of that in the National Environmental Management Act, Section 28. It wasn't initially retrospective. There was a court case, went to court. The court said, no, it's not retrospective. And then Parliament changed it. So they're absolutely able to make this retrospective. And we need to do something in this country about regulating the declining mining industry as we watch the players with the big pockets move out, move away. And then the people who are affected most are just like this community in Jagersfontein who've had their lives, their properties, their livelihoods disrupted by this disaster.
If not the Mineral Resources Ministry, could another department be involved? Because the Deputy Minister of Water Affairs, David Mahlobo, has been saying that they conducted inspections and that the mining company, the owners, I think Jagersfontein Developments is their name, were told that they were not compliant. Now, the mining company, that company, strongly denies this.
Mm. So, yes, the Department of Water and Sanitation is involved. And I've heard commentary that, the dam should have been registered under the Water Act. And there is an investigation pending. So we'd have to see what the outcome of that investigation is and, when the non-compliance actually occurred. Because if a non-compliance occurred before the transfer of ownership took place, criminal liability doesn't end with the transfer of ownership. So if there was some criminal liability that attached to the non-compliance of this dam, then that should also be investigated.
Well, I was going to come to that. So change of ownership doesn't change anything. If you behave badly, you still have a liability even if you sell the thing.
Change of ownership changes your duties under the license. So that does shift. But criminal liability happens at the time that criminal infraction occurs. So, just as we were discussing another case, the Career Ranch tailings facility, which is a huge tailings facility that the DMRE has authorized on the doorstep of the Vaal. There's also a case there of criminal liability potentially. So the investigation should really be looking at that aspect as well.
There's another issue around where the dam was built, and I don't know, if this is a legal issue or not, but let me put it to you. So you have a tailings dam, which we know is built with sludge and I suppose the correct English word would be muck. Some of it may well have heavy metals in it. It's not water, right? Water's the main component of it, but there's not stuff you want your children to play in. And they build this tailings dam in a position that is geographically higher than a human settlement. And we've known for quite a long time as human beings that water tends to flow downhill. One of the questions would be, how on earth did that happen, that a tailings dam is built above a human settlement? It really, maybe there was nowhere else to put it, but still, you've got to ask a question around how it could be that it was built here in the first place. Yeah.
So, the mining of this particular area goes back to the late 1800s. So, it's more than 100 years. And it's not to say that when they started constructing this facility that there was a settlement. The settlement might have come to the mine. But the thing to think about is, while there was awareness of risk, that nothing was done to warn, to educate, to potentially assist these communities, that they were aware, and they were aware of this danger. They were talking about it. So that's a bit more complicated. But definitely we need to be looking at where we've got these structures all over the country and start to do something about regulating the liability and the risk.
There are plenty of mines around this country, probably thousands of them, that are just abandoned. It might be very difficult to know who owned them. The people who owned them may no longer exist. The owners themselves, if they're physical human beings, may have passed on. The companies may have been bought and sold a dozen times. Is there a lot of sort of liability lying around that no one's taking responsibility for? A lot of dangerous stuff that no one's taking responsibility for?
Yeah, well, I think in this case, we must be very clear that it's not. It's not an ownerless and derelict mine. We know who the owners were, and we know who the current owner is, so it doesn't fall into that category. The ones where the owners have long gone, and I do think that information is available, the Council of Geoscience, the department's own records. The Auditor General has said that the South African state is not doing enough in terms of rehabilitating those mines. But, that's water under the bridge. We need to be looking at the water that is flowing under the bridge. And we've got segments of our mining industry that are declining, and we need to put measures in place now, law reforms that stop this past the parcel, because that's what's happened here. It's passing the parcel to operators that have shallower and shallower pockets, and the risks increase.
The risks increase. We're going to have more disasters like this and probably more illegal mining as well that comes with it if you don't rehabilitate a mine properly.
Correct.
Professor, thank you. Professor Tracy-Lynn Field is a professor of environmental and sustainability law at Wits University. Do appreciate the time. A lot more to come on Jagersfontein. One can just sense the lawyers sharpening their pencils. Well, this